Okay, I am currently sitting in a hot car to do this recording, so I'm going to try and be quick about this one. But this recording is going to be about Kessler v. Mortensen, or I should rather say it's going to be about Law School Foundations 2. This is what we focused on this morning. And the purpose of this, the takeaway I should say, is to examine how the rule of law changes over time. So Kessler v. Mortensen is kind of an extension off of Brown. Mortensen's are the defendants, CRM Construction is the plaintiff, and the background is that Eric Kessler was a child who trespassed on a residential construction site to play hide-and-seek. And during the game, he fell through a hole, which was a pinning stairway, and was hurt. And so his mother sued for damages. The defendants, the construction company, said that because of Taylor and Featherstone, they were not liable for the injuries caused to the child because he was trespassing on a residential construction site. So that part right there is important. So therefore, the attractive nuisance doctrine does not apply in this situation. In the the trial court, in the appellate court, the defendants won, meaning the construction companies won, and the Kesslers appealed. So the legal questions here are a little different because this is, ultimately the court doesn't give a answer to what this case in particular should be, but the legal question is a company reliable for the injuries caused to a child at a construction site? And along with that, should we overrule Taylor and Featherstone in regards to trespassing children in construction zones and apply that to the attractive nuisance doctrine? Okay, so here's how the court held. So it held that owners are liable for injuries caused to trespassing children in residential construction zones, and that overrules Taylor and Featherstone. Those two cases were examples of exceptions in the past, so they overruled those two cases. Further, the court adopts Section 399, which is a restatement of the second restatement of torts. And finally, each case is going to be evaluated on a case-by-case basis. Trial courts. And then the result of this case was that the trial court ruling in favor of the company is reversed, and the case is remanded for further trial, so it didn't give an answer as to what would happen on this trial. Okay, so let's go over an analysis real quick. So first, it's important to understand what the attractive nuisance doctrine was supposed to do. It's supposed to protect children from injuries that occurred to protect trespassing children, making the owners liable for injuries on objects that are on their property. And this is because children should not be tried as an adults, where their maturity level does not allow them to make that recognition. Okay, so the defense claimed that to make construction sites safe, they would need to build a lot of fences, which would incur a lot of cost to the companies. And so that's why they should remain as an exception, because this would increase housing prices. The court disagreed because building a home is a temporary job, and as a result, those expenses are then temporary. Okay, so let's turn into the meat and butter. I don't know if that's what the phrase is, but of this case. It's where they then overrule. That analysis is how they overrule Taylor and Featherstone. But now we're going to examine Brown, and this is what we focused on during our cases example. Brown was the initial rule of law, and now they're going to adopt Section 3, either 339 or 399, one of the two, which second restatement of torts. And that has 5 parts to it, 5 elements that you must meet. First, the owner needs to know that there's a potential for children to trespass. Second, they need to have an idea that injury may occur as a result of the trespass. Third, the child does not know of the risk of the area because of their youth. Fourth, the burden on the owner is slight in comparison to the risk of the child. And fifth, the owner fails to exercise reasonable care to limit the danger and protect the children. It's also important to note that the construction sites are now included in this because of this case. So they dropped Brown and adopted this second restatement of torts, which they adopted because several jurisdictions had already adopted it. Okay, so there's three big takeaways from this. First, Taylor and Featherstone is disavowed, meaning construction sites fall into the attractive nuisance doctrine. Second, the court drops Brown as a rule and uses the 339 second restatement of torts. And finally, this case in particular is going to be remanded for further trial of the lesser courts. As far as the lecture goes with this, we wanted to focus on briefing. So you wanted to be brief. You wanted to make sure that you included the case components. And I actually just went through a brief on this audio. Granted, I did it a little broad and quickly. But the components of a brief needs to include the citation, the facts, which is the background, the history, the procedural history, which is what was ruled in the trial court, so on and so forth, the issue, which is the questions that are here, the rule or the ruling, what's the law that they're going to have, and then the holding, which is the result of this case based off of that rule. And then we go into an analysis or the rationale for why they made that holding. And then concurring and dissenting opinions. And typically, they are not considered part of law. A concurring opinion is an opinion that agrees with the result, but maybe has a different justification to get that result. And a dissenting opinion is an opinion of dissent where they don't agree with the result. Okay, so tips when we are making a case brief. We want to pay attention to the conversation. If we miss something, we'll want to make notes on our briefs. They should be lively. They shouldn't just be set once and kept that way. They should always be edited. Second, we can use context clues like the table of contents of case books to help us know what should be on what the case is talking about. We can also use the class syllabus to have a good idea of what that is. And we can use a dictionary. The Black's Dictionary is the legal dictionary, which can be used to help us define legal terms. All right, so that's what we talked about in Law School Foundations 2. Hope that was enjoyable. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.